I'm criminal trial attorney Sara Azari, and this is Serving Justice, where we dig into what really matters in a criminal trial, the defense. Diddy escaped the most serious counts against him: sex trafficking and racketeering conspiracy, otherwise known as a RICO violation. But why was he even charged with something that's typically used against gangs and even famous mobsters, such as Al Capone and John Gotti? The truth is, prosecutors have been using RICO to take on rappers, doctors, and even teachers, anyone and everyone. So we have to ask, what is happening here? And was it a mistake to charge Diddy with a violation of the RICO statute? Is this government overreaching? The evolution of RICO. Joining me now is NewsNation reporter Safia Samee, fresh off coverage of the Sean Diddy Combs trial, as well as former federal prosecutor, criminal chief for the U.S. Attorney's Office in Los Angeles, and partner at Hecker Fink, Mack Jenkins. Also, fun fact for our viewers, Mr. Jenkins is who signed off on the search warrants for Sean Diddy Combs's L.A. home. So thanks, Mack, for keeping the streets safe of baby oil and Astroglide. Thanks for joining me today. So listen, Safia, first of all, I want to go into some of the historic cases where this RICO statute was applied by the government to prosecute defendants. But Mack, what goes into a RICO investigation and how has it changed over the years?
Sure. I think one of what we would call sort of the magic of RICO investigations is that it really encompasses a lot of facts, a lot of evidence, a lot of individuals, a lot of subjects that ordinarily would either, one, not be charged in a federal criminal case or charged in a bunch of separate criminal cases. It brings them all into one conglomerate of a case that ultimately can sound very complicated and certainly can be complicated to build. The RICO prosecutions I did took years. It took dedication and collaboration from federal agencies, state agencies, regulatory agencies to really build this complex case that in the end, ideally is straightforward to a jury to understand and convict, from the kingpins to the enforcers to whoever else is involved in this criminal enterprise.
Except it's really complex also, even though it's simplified into one sort of cluster. Safia, along with the Combs case, Sean Diddy Combs case that, we just covered on this segment, you closely covered the R. Kelly RICO case in 2021. How was that case able to get or reach a conviction where prosecutors couldn't do it in the Combs trial?
Yeah. So I think in the Combs trial, there was very much a question of victim versus volunteer. And there was no volunteers in the R. Kelly case. These were 13, 14, 15-year-old girls sitting in that courtroom. They showed photos of these girls at that age, and there was no question that they were children. So I think that with the Diddy case, the defense really went in. We talked about this, Sarah, about consent and how there was a long-term relationship and there was a give and a take. And I don't think that was the case in R. Kelly. Obviously, these girls didn't have agency. They couldn't give consent. And so I think that was really one of the big reasons why it didn't land for Diddy, but it did for R. Kelly.
And yeah, I think that was a big difference. Otherwise, we had, the RICO statute, we had sex trafficking. So it was really similar in terms of the charges.
It was.
Mack, I think the big question we're getting at is, have prosecutors expanded beyond what RICO is designed to do? Because, it is a go-to. It is what defense lawyers call the wild card of the government. But is the government overreaching in its modern day use of RICO?
Sure. I think my lawyerly response is it depends who you ask. I think there's certainly been more recent examples when that question has been more frequently asked, in part because, as we always say, sort of the proof is in the pudding, meaning it's up to the jury. As I described, we want to make a complicated, comprehensive set of facts very simple for a jury to understand that a federal crime, a serious federal crime was committed, or crimes committed as part of this racketeering enterprise. But if a jury disagrees, then something went wrong, either the presentation or the evidence or the theory, which I think you're getting at. We've prosecuted, when I was at the U.S. Attorney's Office in Los Angeles, politicians, Jose Huizar, city government, state government, street gangs, both Crips and Bloods and Mexican Mafia. Also, you've seen the Varsity Blues case, which is academics, sports players, parents. There's all these different expansions of RICO that originally was the Italian mob. That was it. So
Mhm.
certainly yes, it's expanded, and I think it's expanded in appropriate ways. But I think anytime there's an expansion, there's a risk of overreach. But ultimately, maybe that's what the jury decided in recent cases, and ultimately it's the jury's question, and they answered it in different ways in different cases.
I mean, my God, I didn't even think about. I was familiar with the Jose Huizar case because he was my, where I live in LA. He was my representative, my city representative. So I was very much following his prosecution. I know you worked on that case, but I didn't realize it was a RICO charge, and then I also didn't remember that the Varsity Blues case was a RICO charge, which is a case that I commented a lot on in media. And it was, extraordinary in all kinds of ways, but it's just so widely used. So going to Safia on our cases for this week, I think you've got John Gotti first, right?
I do, yeah. And
Okay.
it's just like Mack said, it's been a very interesting evolution with the case with use of RICO. So we've got mob boss John Gotti. He was the head of the Gambino crime family in New York. He was actually acquitted in 1987 of racketeering and conspiracy charges related to illegal gambling, loan sharking operations, armed hijackings, and at least 2 murders. He ended up getting the nickname the Teflon Don because he beat those charges largely because of jury intimidation and witness intimidation and threats, very on brand for the mob. But prosecutors didn't give up. They brought a case again in 1992. He was convicted on all 13 counts and sentenced to life in prison.
I mean, Mac, there's no doubt that this was what the statute is about, right? This is what it's intended for, right? I mean,
Yes.
okay. So we're good. We're good with John Gotti, but then we move on to biker gangs like the Hells Angels. What do you have on
That's
the
right.
Hells Angels?
Yes. So in 1979, the Department of Justice charged 33 members of the Hells Angels biker gang under RICO. They said that specifically the Oakland chapter was a full-time criminal organization that was engaged in the distribution and manufacturing of methamphetamines. That case ended up failing. The trial ended up in a mistrial because the jury just could not reach a consensus.
So, Mac, one of the questions that's often asked is this sort of the linchpin to a defendant exercising his right to go to trial, or is it something that the government ever agrees to negotiate out in a plea deal?
In terms of the racketeering charge?
Yeah.
Sure. So I think the upside for racketeering as a prosecutor is what I alluded to earlier. There's the very significant likelihood that every bad thing, criminal adjacent, bad morally, that a defendant did is going to come in if you can link it to, in some ways, to furthering the purpose. It doesn't need to substantially or be the core of the racketeering purpose. Easy example is if in a gang case, in a street gang case, in a Crips and Bloods case, gangs have meetings. They have what they call hood days, where they go to the park, they wear their constitutionally protected, gang attire, their numbers, they're out in the park. That's all First Amendment protected activity. But you put that in a gang context, where what we're saying is that actually was how them demonstrating their power over that park. And those numbers that they're affiliated in, it shows their association, shows their brand identity, which is something you need to prove in a RICO case. And so you bring that all to bear, and the evidence just keeps streaming in. So it depends on what a defendant is willing to accept. One, whether they are a member of an enterprise. In the Mexican Mafia cases, it's difficult to get the Mexican Mafia members to admit the Mexican Mafia exists. So that's a big deterrent for pleading guilty. And then other stuff, what are they willing to admit is actually part of the criminal enterprise? Some of them are saying, no, we're just protecting our neighborhood. I sold drugs, fine, for selling drugs, I'll admit to that. But I'm not going to admit our hood days is some way furthering some criminal enterprise. So again, it gives us a lot of flexibility and leverage, but there also is reasonable pushback from a defendant who's saying, okay, you got me on this stuff, but I did this for myself, to feed my family, and I'll admit to that crime, but not this big conspiracy, this racketeering, this frightening thing that you're trying to paint us out to be.
And you hit on something really interesting, which is people always ask, well, these are doctors. I've represented doctors. I've represented pharmaceutical professionals who've been charged with RICO, and they say, well, we're practicing medicine. We're running a pharmacy. So that's not what we were doing. That was not a criminal enterprise. But you hit on something interesting that answers that question, which is that doesn't have to be the only purpose of this sort of enterprise, right?
Absolutely. And I think Safia mentioned it too. Like there can be legal entities engaged in criminal racketeering. There can be a motorcycle gang that is totally legitimate in the sense that they do legitimate things. They like motorcycles, they hang out with each other, do fun things. And that can still be a criminal enterprise based off other conduct they do as part of their legal entity. So if you're if a doctor and you're treating your patients, but you're also engaged in some sort of healthcare fraud or other criminal activity, and you use, for example, your office or your client list to further your criminal activity, as long as that typically would say is like substantially facilitated by the enterprise. So it doesn't need to be the sole purpose, doesn't need to be the majority reason you have your doctor's license, your business. But if that doctor's license, if your office substantially facilitates your ability to create crimes in your enterprise, then that all comes in. And that's not a defense. That is just an explanation of why you're such being really good at criminal activities, because you have a lot of opportunities that a doctor would in that example.
And, I think that one of the things that I was talking about, not a lot of people were talking about this when the Diddy trial was going on, was the forfeiture allegation in his indictment, and how the government would essentially take away his entire, I think reportedly as $400 million of net worth. And so then the argument is, well, that wasn't all because of his criminal activity. But to your point, it doesn't really matter, right?
Yeah, I think I'm glad you talked about it, because you're right. I think it's under talked about, but I will tell you, in the U.S. Attorney's Office, we had a very aggressive, very forward-thinking asset forfeiture section, where they would always say, "Can you charge as a racketeering, because potentially everything is forfeitable that the racketeering enterprise touched." So again, when you talk about this commingling of a legal enterprise that is also facilitating a criminal enterprise, or vice versa, potentially all of that is at risk. And so, yes, and I haven't looked at the specific forfeiture allegations in the Sean Combs case, but I expect that that is something that caught the attention of prosecutors, because one, you want to send people to prison as a deterrent factor, but you also want to dismantle that enterprise so that someone else can't just step in and take over the next PD or what have you. So part of it is actually not just criminally punishing the individuals, but it's dismantling that enterprise so it can no longer exist.
Wow. I mean, Safia, this is good for Jane, right? Her rent's still going to get paid. I guess. Anyway, all right. You've got the Mongol motorcycle gang or Mongol motorcycle club, sorry, as well, right?
Yeah. And I'm so glad, because you guys both talked about First Amendment here and forfeiture, because this case hits on both. So in 2013, the government filed RICO charges against the Mongol Motorcycle Club itself. And a jury found them guilty, saying the group engaged in criminal activities, including murder, attempted murder, and drug trafficking. The interesting thing about this case, and I'm so curious to hear both of your thoughts on this, the government sought forfeiture of the club's trademark logo as a part of their indictment. And the jury actually agreed, saying that there was a direct connection between the gang's crimes and the logos that prosecutors said formed the core of the motorcycle gang's identity. That was challenged by the ACLU for First Amendment rights. But yeah, that was such a crazy thing for the government to seek.
So, Mack, were you prosecuting this case?
I was a baby AUSA when the case was going on, but I will say by the time it ended, I was a very old, gray-haired AUSA because of what Safia mentioned, that the litigation continued about the trademark, and it was landmark litigation. So that continued. I think, frankly, it ended like a couple years ago, but it started in 2008.
So
I was involved in the latter end of the process, not the beginning end of the process.
So how is it that so the government gets the trademark to the Mongols logo, and then what? They sell merch?
If you've seen the U.S. Attorney's merch, it is not great. So maybe we should. It's boring. Get some more funds that way. But no, it actually goes to what I said before. It's really for us about, one, criminal deterrence for the individuals, for organizations like it, but dismantling that enterprise.
Right. Okay. So that it's done and done, basically, including this logo and any trace of it.
A great way to kill a brand is to have the government take it over. So you will not see too many Mongols jackets being worn by AUSAs or employees there. But but I'll touch on. But ultimately we lost. So part of it was reversed because it was, according to the Ninth Circuit, government overreach to us having us wear Mongols jackets to the office, basically. So we didn't get to do that. But there is a Mongol jacket in our sort of Hall of Fame. My former office is Hall of Fame.
That's interesting. I think we need to go on eBay and see if there's anything vintage we can all collect. Anyway, and then RICO's often the go-to statute for Fannie Willis out of Atlanta. So, Safia, what happened there?
Yeah, very interesting. So far we've been talking about federal RICO cases. This is actually a state case out of Georgia. So 11 teachers and administrators were charged and convicted under the Georgia state RICO law after a jury found that they participated in a scheme to falsify test scores of students when reporting to the state. Basically, they illegally altered answers, did some shady stuff. Now, interesting enough, back then, this is in 2015, Fannie Willis was the assistant district attorney. She's obviously now the district attorney of Fulton County. She was the co-lead prosecutor on that case. And we obviously all know her because she wanted to bring the same state RICO charges against Donald Trump for election interference.
I mean, do you think this is a real criminal enterprise, Mack? A bunch of teachers changing grades?
That one, it's a state case, and two, so I'm less familiar with it, and they're different state racketeering laws. Yeah. But also, I may be the wrong person to ask because I was a proponent. I mean, like you said, we prosecuted Jose Huizar and a deputy mayor of Los Angeles, and it was the first time any elected or appointed officials in the Central District were charged with federal racketeering. And a jury, Jose Huizar actually pled guilty to racketeering, so there was no question. And then a jury convicted Ray Chan, the deputy mayor of LA, of racketeering. So I'm a proponent of appropriately, I will say, evolving, maybe not expanding, evolving the RICO statute. So I support any prosecutor's desire to do that as long as it's done appropriately. But then realistically, you need to understand and hear the jury's feedback when they think there's overreach. But I couldn't really comment specifically about the facts of those cases.
Yeah. All right. And then I think we have R. Kelly, which then sort of brings us to Diddy. Right?
Yeah, absolutely. R. Kelly convicted in 2021 of federal racketeering, sex trafficking charges relating to the coercion and transportation of women and girls in interstate commerce for illegal sexual activity. I really think this is what prosecutors looked to and was the building blocks for when they wanted to bring the case against Sean Combs. Obviously didn't land, but.
Yeah, I mean, look, he was indicted in Eastern District of New York, which is a sister office to the Southern District of New York, prosecuting Sean Diddy Combs. They have sort of been on a winning streak of securing sex trafficking and RICO charges against high-profile defendants. But like we talked about before, I think it's apples and oranges because of consent. I think in R. Kelly, you had minors who were victims, and in Diddy, you had consenting adults who were after, I don't want to call it a transactional relationship, but one was getting handbags and her rent paid. The other one was after a career. So there really was a lot of evidence of sort of choosing to stay in the relationship. So I think it made a big difference. But do you think, Mack, this is sort of a trend in this jurisdiction and otherwise against rappers in the music industry? I mean, as someone else next from that world? Or do you think the outcome in Diddy may have put the brakes a little bit on like the SDNY's use of RICO when it comes to people in the entertainment industry?
Sure. I think not just SDNY specifically, but certainly I'm sure there's some lessons and takeaways. But certainly it's in a high profile case, when it goes well, it I'd say inspires and gives examples for other prosecutors across the country. And when there's challenges, ideally it's the same result, just the opposite way, more deliberate, more conscientious. And again, that's not to say the prosecutors there were either, but I'm sure, to your point, Safia's, they were saw an example in the R. Kelly case and saw similarities enough that they thought they could move forward in SDNY. And he was convicted on some things. And sort of to flip it on its head, I think a lot of people, myself included, when I saw, and I was still in the office when the R. Kelly indictment came down, I thought that was aggressive. It is very rare to do a single defendant racketeering case. And the racketeering cases that I charge, and I'll stop talking about myself at some point, but there were multiple defendants. One had 72 defendants. In our public corruption, we had 15 defendants. Because when you're talking about, this is a criminal enterprise, people think, oh, the mob or this big organization. But then when the indictment lists one person, it's different. But it wasn't done in the R. Kelly case. So I think, again, it sort of depends on who you ask, and ultimately the jury's answer is the most responsive. But I thought the R. Kelly case was aggressive or expansive, rather, and the jury was very convinced that that's what was happening there. So I think they'll just continue to retool and rethink what facts matter the most. But ultimately, in any victim case, the victims can carry the case, and sometimes the victims can be where the difficulties arise.
I kept saying with Diddy, like, what is he conspiring with himself? Like, this is weird. I mean, the jury's going to notice that. And one of the alternate jurors has given a lot of media interviews. And I think I think it's clear from his interviews that the jury got it, in that, he said, look, this guy is a very flawed man who's done a lot of bad things. And like Mack, you were saying, RICO criminalizes people that have done really bad things that may not have been charged crimes or chargeable crimes, but in this case, they're like, he was really flawed. He did really bad things, but not the things he was charged with, and so they got it. But there was a real danger of them looking at this really despicable guy who's done really horrible things and convicting him. I mean, there's always that risk, and when they came back with these questions, I don't know, it was towards the end of their deliberations, I was like, oh Lord, I think he's going down on sex trafficking of Cassie, but obviously he didn't. So my two questions I have for you, because this is about you, actually, you were wrong about that. How did it feel to you when those warrants crossed your desk and you were signing warrants for Sean Diddy Combs?
I'll be limited in what I can say, because some of this is sort of behind the curtain of the office. But the search warrants were public and they get disclosed in discovery. But the first thing that I thought was, why aren't we doing this case? That's what I think when a warrant that sounds, when you read it, because obviously for people to know, the way a warrant works is a federal agent writes a probable cause warrant that we present to a judge, goes to us, we review it, work with them. But you see a very compelling narrative about the crimes being taken place. And here, the crimes that were taking place were in our backyard. We're in the Central District. We're in Los Angeles. And then obviously I recognized the name, but it wasn't just the name. We don't do head hunting, but case hunting, like impactful cases. I'm like, why aren't we doing this case? Frankly, similar to how it felt in Varsity Blues, because a lot of that conduct, USC, UCLA, where I went, a lot of activity took place. So as a prosecutor, you're like, this is interesting as an academic point. Then as a sort of competitive prosecutor, like, why aren't we doing this case? So those were my first two thoughts. Like, wow, this is fascinating. Also, why are we not doing it?
But you didn't. Okay. And why did New York take it and not the Central District of California?
They are often on the forefront of creative theories, getting facts. And obviously, Mr. Combs had conduct in New York too.
Yes.
So a lot of times there's multiple jurisdictions. I think they took to the case and saw the legal theory. The legal theory they understood was, I think they saw it before other people did. So they pursued it, where I think a lot of other offices, sort of to what you said, that juror said, be like, this is a bad guy doing bad things, but I don't see a federal criminal case out of it. And sometimes other offices do. And so they move forward. Because that was the first I'd heard about it when I saw the
So you think that the Central District of California would have indicted him had it come to their attention first?
Ultimately, that would have been a conversation with our U.S. attorney and myself as the crim chief. And I would not say that. What I was saying is that it definitely, in a probable cause warrant, where you're just hearing one side and one narrative, it sounded like a very creative and compelling case, when it was also on the heels of sort of the R. Kelly, where you hear about the minor and the violence, and like certainly sex trafficking, I will say, gets the attention of any federal prosecutor, particularly when it's minors in violence. So certainly it would a case we would take a hard look at, but I can't say one or the other whether we would pursue it as SDNY. Ultimately did, and I think they had the evidence in the jury.
And it was a colossal fail, seriously. But let's talk about, just before we let you go, where do you see him landing in terms of a sentence? The prosecutors indicated when they were arguing for detention, they indicated something like 4.5 years, but since then they've come back in writing saying something, I think around, Safia, correct me if I'm wrong, I think they mentioned 7 years or something like that. This judge, what?
I think it was less than 7 years. I believe it was more of like they wanted to go full with the full 20. And then later on, I believe it was closer to like 4 to 5.
Yeah, full 20, like consecutive sentences. All right. So I would think they would chill out after the colossal fail, in the verdict. But anyway, that's not going to happen. Even with Diddy, who obviously his violence was on full display with this judge. The judge is the ultimate arbiter here, and he saw who this guy is and what he's done. The bribery, the blackmail, the violence, the intimidation, all of those things. And those are aggravating factors, which are going to get considered. But on the mitigating side, Mack, he's also got a very documented history of clear addiction, a lot of drugs, a lot of drug use, probably sex addiction too. I mean, I think all those things are going to factor in as well. So looking at his guidelines, I don't need you to bring out the book.
Yeah.
What do you think? Where do you think he's going to land? Because the government's obviously going to want, the max.
Yeah, and I think you touched on it, but ultimately, I think it's which Sean Combs the judge saw through that trial, right? There's a lot of the activity you described, the criminal activity, but the criminal adjacent activity we were talking about, the aggravating factors, which, notwithstanding an acquittal on the most serious charges, as you pointed out, are totally game for what we call the 3553A factors, the other factors a court can consider, both aggravating and mitigating. And I think he has, like you said, a lot of both. So whether this court found that the aggravating factors, even if a jury found weren't criminal, but still showed someone who could be a threat to society on an ongoing basis, then I think he's looking at a term closer to double digits. But I think if the court saw sort of a very different Sean Combs and saw in the acquittals something similar in terms of, okay, this is a person I would not want, my family to be around, bring him into my home, but these types of significant sentences are for people who are ongoing threats, recidivists. And as you get sort of past 5, it's more about, is this person in danger now? Will they be in a danger in the future? Will they be in danger in 5 years? And I didn't sit through the trial, and I'm not the judge, but I think ultimately the judge is going to be asking themselves that question. In 5 years, who is Mr. Combs going to be, to the extent you can predict anything? But he heard a lot of evidence about what Mr. Combs has been for most of his life. And whether that's just a deeply flawed celebrity with compelling mitigating factors, or some monster that as soon as he gets out will repeat the same thing, I can't say for sure, but I think.
Well, Mack, when coincidentally I met Mr. Combs a couple days ago in lockup, and he seemed pretty humble to me, but we'll see. But what I think what doesn't help him is that even after Cassie Ventura's lawsuit and settlement, and when he was aware that there was an investigation, his lawyers were literally contacting prosecutors at SDNY, trying to open dialogue. And of course, it wasn't going. But even after all that was going on, and he's in New York, he was still using drugs. And so, I mean, the judge could potentially look at that as part of the larger conduct. He was still the same guy. He was doing the freak off. There was baby oil in the hotel room. There was drugs. There was a lot of cash, all that stuff. So I also don't think that's really good.
I was going to ask both Sara and Mack, do you think, he denied bail, which I thought was surprising. Do you think that's kind of a little bit of an indicator, a sneak peek of where his train of thought is when it comes to sentencing time?
I'll let Mack answer that.
Yes. But I think the opposite is more true, meaning if he had let Mr. Combs out, I think that's certainly an indicator of how lenient or low the sentence would be. The default typically in a case like this is to keep them in prison. The jury has now found at least some of the facts that this person is now you are convicted. The presumption of innocence, the cloak of innocence has been removed by a jury and revealed a federal criminal defendant who is likely to get time. So with that sort of mask unveiled, it's not too compelling or telling, but it would have been much more compelling had he granted bail. So I was less surprised. I think, Sara, you thought maybe he was going to get bail. And I think that was definitely what was on the table. But I also don't think it means he's going to get the stat max.
Yeah. And I think my conversation with a client in this position would be, look, sorry you didn't get bail, but you're going to be doing some time. So what's the point of getting out, celebrating 4th of July with your family, and then turning back and going right back in? He is going to get time. and it's, I don't know that necessarily, like the Mann Act violations that he was ultimately convicted of, those were the nothing burger in this indictment. Those were the sort of the hook that he was he was definitely guilty of those violations. And but ultimately what the government really wanted wasn't that. So I also don't know if the judge might, I don't want to say turned off, but he's probably did see through the government's overreaching as well. So, but yeah, I mean, I think Mack's on point in terms of like how much of a deterrent or punishment is necessary for someone like him, given what the judge has seen, even though he wasn't convicted of it. Coincidentally, Mack and I met on when he was a baby AUSA, and I was like a kind of a baby lawyer. We met on a passport fraud case, another nothing burger, 6 months, 0 to 6 months exposure. And my client got 4 years because of the aggravating factors, his tattoos, things from the past. I mean, you name it, all of it came in at sentencing, and we had a really good judge, a very fair judge. But anyway, ultimately it was a loss for Mack as well. So, he thought I have to hang my bar card, but that definitely was not the case. So anyway, Mack, thanks so much as always for your brilliant insight and for joining me today. And Safia, as always, thank you so much for bringing all this history to us. And for our viewers, thank you for following along. We will see you next time. Until then, the defense rests.